Welcome back, guys. This is Professor Kachalia, and I welcome you to the second episode of Who Wants to Be a Logician. I hope you have solved every MCQ from the episode number one, and I hope logically, conceptually, analytically, your concepts are very, very clear. If yes, if your episode one is very, very clear and you are done with that, let's begin with the episode number two right here, right now. Episode number two begins where we're gonna find out who wants to be a logician. Let's begin with the question number one. On your screen now. Due to the non-compliance of certain requirements under the Companies Act, mind you, non-compliance of certain requirements of the Companies Act not being fraud. Okay, we are not talking about fraud over here. A company is required to restate its financial statements for the financial year 16-17. After the financial statements were restated, they found out that the managing director of that period has been paid some extra remuneration. If the managing director of that period has been paid certain extra remuneration, you tell me, can that remuneration be recovered from that managing director if he is no more a managing director today? Check your answers. A. Nothing can be recovered from the ex-managing director. Ex, because he's not a part of your company today or not a managing director today. B. Excess amount shall be recovered, irrespective of whether at present he is an MD or he is not an MD. We don't care. Money should be recovered. Option C. Only 50% can be recovered. Balance cannot be recovered because fraud is not. And option D. Only 25% of the amount can be recovered because fraud is not involved. So guys, put your thinking caps on, pull up your socks, your time starts now. I'm up, and let's check the answer whether it should be or not. You tell me. Yes, sir. Of course, sir. If we are giving some money to somebody, and by mistake, if we have given some extra money to somebody, then naturally, sir, the money will be recovered from that person. The excess amount paid will be recovered from that person. And let's check the answer. It is B. As you can see on the screen, answer is B. Excess amount shall be recovered irrespective of he is an MD or not. I hope this was a very, very simple question for you. Let's go to the next one without wasting any time. Question number 2 on your screen right now. Capable limited appoints Mr. Vikas as the MD of the company. All right. The board of directors entrusted means gave him some powers. Mr. Vikas has been appointed as a managing director of the company, and the board of directors have given him some powers. He is not ready to do administrative acts which are authorized by the board of directors. He says, I am the managing director. I will do anything and everything that suits me, that I want to do. And board of directors, if you are giving me some job, you are allocating me some job unanimously when the entire board selects you as a managing director and they are giving you some powers. He says, I will not do all that. I will not do all that. Okay. Keeping in view that he shall be entrusted with substantial powers. I am big person. I want big powers. Decide the acts which Mr. Vikas can undertake, here as a managing director where he is not yet authorized by the board of directors. Let's see options. First, to draw or endorse a check. To draw or endorse a check on the account of the company, meaning money of the company is involved. And mind you, wherever the money of the company is involved, proper channel of authorization has to be followed, because where money is involved, of course, it is a matter which involves public interest, because the money belongs to the company and company belongs to the public. So naturally, public interest is involved, and that is why, of course, Mr. Vikas cannot endorse or draw any check unless he is authorized to do so by the board of directors, right? Second one, signing the financial statements of the company. Can he do that? Well, sir, signing financial statements, yes, as a director of the company, managing or not, he has the power to sign the the financial statements. Third, draw or endorse any negotiable instruments. Sir, already we said for A, answer should be no. To sign any share certificate, can he do that? Signing of a share certificate as a managing director where he is even not authorized to do that? Think. Answer. Your time starts. Did I already tell you the answer by mistake? I think so. No? Well, your time starts now. Check it out. All right, time's up. And the answer is no prizes for guessing this answer. Of course, there has to be B only, right? Let's go on to the next question on your screen right now. You are a whole-time director of Choco Chips Private Limited. Choco Chips. And wish to appoint Mr. Vanilla Sequeira as the managing director of the company, who has attained 72 years of age. Mr. Vanilla Sequeira has attained 72 years of age, and you still want to appoint him as the managing director of the company. However, the board got to know about the fact that he is 72 years old. They know that he is 72 years old, and no company shall appoint or continue the employment of any person as a managing director or whole-time director or manager of the company who is below the age of 21 years or attains the age of 75 years. Yes, 75? 70 years. All right. You are requested by the board of directors. You are a chartered accountant. So you are requested by the board of directors to evaluate the situation, whether it is possible to appoint Mr. Vanilla Sequeira as the managing director of the company, even though he has attained 72 years of age, which is of course more than 70 years. Is it possible or not? Think and answer. The 4 options are on the screen. I'll give you a hint. Pause the video. Refer section 196. Come back. Select your answer. And it has to be the right answer which you select after you go through 196. But you will get 30 seconds to decide. Your time starts now. Alright, time's up. Let's check the answer. Did you get the answer? Is it possible as per 196? Do they say it is possible? Of course, sir, it is possible. Ordinary resolution or special resolution? Sir, we have seen the provision. It requires ordinary resolution, central government approval. Yes, is that so? Then I will tell you, go update your notes, because the provision that is there now and the latest one that requires a special resolution to be passed in the meeting of the shareholders, that is the general meeting. All right. So yes, he can be appointed as a managing director by the shareholders by passing a special resolution. That is a proviso. A proviso which is in section 196 has given this power to 196, wherein he can be appointed as a managing director. All right. Let's go to the next one without wasting any more time. The next question is on the screen as Mr. A. He was appointed as a manager of PQR Limited for a period of 5 years on 20th June 2015. So 2016, 17, 18, 19, 20. 20th June. So 19th June 2020 should be his last day in the office. I repeat, 5 years they said, right? So 16, 17, 18, 19, 20. 19th June 2020 should be his last day. Considering his performance and dedication, okay, before the completion of his term, the management decided we want to reappoint him as the manager of the company. On which date the reappointment shall be considered as valid? We are saying on which date the reappointment shall be considered valid. So here they are not asking you what will be his term. They are not asking you when can he, what will be his term if he is appointed as a managing director. They are not appointing you if he is appointed as a manager of the company, determine his tenure in the company. No, 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 no. The question is very, very straightforward. They are asking you if Mr. Who is that A? Mr. A of PQR Limited has to be appointed as a manager, reappointed as a manager, then on and from which date the reappointment shall be considered to be valid. All right. Think very precisely and answer. Should I give you a hint? Yes. Refer section 196 again if you have not known the answer by now, and your time starts now. Time's up, time's up, time's up, time's up, time's up. So what is the answer? Is the answer A, B, C, or D? Is the answer 2019, 24th June, or 1st February 2019, or 12th March 2018, or 10th September 2018? Four options are there. If you have read the provisions of section 196 very, very clearly, where the provision of appointment is given, reappointment is given, over there, again, a proviso is very clearly specified, stating that no reappointment shall be made. What does the proviso say? Provided that no reappointment shall be made before the completion of last 1 year being pending. Yes? Before the completion of the 4 years or 1 year before the expiry of his term. If I go by the language, it says no reappointment shall be made before 1 year from the expiry of his term. Which means what? No reappointment shall be made before the expiry of, before 1 year before the expiry of his term, 1 year before expiry of his term. His term gets expired on 19th June 2020. 1 year before that, 19th June 2019. Right? So, provision, as per the provision, you can make the reappointment on any particular date after 19th June 2019. In other words, any reappointment made before 19th June 2019 shall be invalid. 19th June 2019, can you see any date which is after 19th June 2019? Yes, sir, I can see option number A, which is 24th June 2019, and that is not before 1 year before the expiry of his term. So answer should be your A answer, A option, that is 24th June 2019. All right, let's go to the next concept. Well, quite a big question, quite big a question, I would say. Lockworth Safety Gears Private Limited pays the remuneration to its directors on a yearly basis. Okay. Company has a whole-time director on board. Okay. Currently, they have appointed Mr. X as the managing director. Company has a whole-time director. Okay. So company already has a whole-time director and they have appointed Mr. X as a managing director. Now the company has to keep in mind that the overall remuneration of the directors, including the managing director, whole-time director, manager, shall not exceed the maximum limit which is given in the section, under section, which section? I'll tell you, 197. If there is more than one managing director or whole-time director or manager, how much maximum remuneration is allowed to be paid? 3%, 5%, 10% or 11%. No question can be straightforward more than this one, right? Section 197, refer the entire section and then make an attempt to answer this. Your time starts. Time's up, everyone. And your answer is, sir, director's managerial remuneration, sir. If you have my notes, when you open this particular section, the second point I have explained the director's managerial remuneration part, where we have drawn a chart in the name of director's managerial remuneration divided in two parts. Yes or no? Over there, if you see, we have specified on the right hand side. We have specified on the right hand side in the second part over there, in the second branch over there, that if a company has any MD or WTD or manager, in that case, the payment to the MD WTD managers overall will be not more than 10% of the net profits. And in case the company does not have any MD WTD manager, then the maximum remuneration payable will be not more than 5% of the net profits. In this particular given example, have they specified in the second line that the company has a MD or a whole-time director? Yes, sir. Which means how much can be the maximum remuneration? Not more than 10% of the net profits. So maximum is 10% of the net profits. Quite simple a question, depending, or I would say, considering your caliber of a CA final student. Yes. Let's go to the next one without wasting any minute. Quite big a question, I must say. Yes, this is not some question where I will read it very quickly or I will speak up very quickly and you will understand. Relax. Read the question peacefully. You're watching this video as a recorded version, I'm sure. You might please pause the video and read the question. I'm not reading the entire question for you. You might read the question. Thereafter, read the 4 options. It might take a couple minutes. Thereafter, I will start with the 30 seconds timer. All right. Your 30 seconds timer will begin the moment I leave the screen, but you need to pause over there. Read the question. Once the question is done, play the video again. Set a 30 seconds timer, which will already be playing in the background, and try to answer within those 30 seconds only. As a hint to this particular question, let me tell you, if you have gone through section 197, you might have an idea that, okay, this particular question has something to do with 197, but what is it exactly about 197? I'll tell you something. If you really want to go through it, go to the schedule 5 part 1. Go through the schedule 5. I'm not even telling you go through entire schedule 5. Go through schedule 5 part 1. Read that and you will have your answer right in front of your eyes over there. I will discuss the answer right after 30 seconds, which begins now. Time is up. Time is up. All right. Are we through? Did you go through the schedule 5? Did you go through the part 1? Did you go through the section 197 provisions very clearly? Yes. If you have gone through section 197 and gone through section 195, schedule 5 and gone through the part 1 and gone through the clause E over there and gone through the explanation number 1 and explanation number 2 which is given for clause E over there, well, I don't even need to discuss the answer then, do I? Yes or no? Well, it is very clearly written. As a chartered accountant, you have to advise whether in a special economic zone, this company is incorporated outside India related provision, whatever is given over here, is it required to be followed? Yes? Let's check the answer. Mr. Ashwin is not required to comply with the conditions of a resident in India. Why? Is he particularly a member of a company incorporated outside India? No, sir. SEZ is in India. But the requirements of resident in India or stay in India of not less than 182 days. Yes? Not 182. Here it will be 12 months. Am I right? Sir, these conditions do not apply to a company which is incorporated or established in a special economic zone. This condition will not be attracted in a particular company which is incorporated in an SEZ. To understand this, as I told you, you need to very clearly refer. I have made this note for your reference, if you can read it. Refer to the schedule 5 part 1 clause E explanation number 1 and 2. What is that? That is a note that I have made for all my dear students over here who are willing to be logicians apparently. See what happens now. Right now this is okay. We are discussing MCQs and I am showing you the questions, giving you time to understand the questions, giving you time to, you of course have the option to pause and answer also. But you know what will happen? The moment you start writing them from exam perspective, no, you will lose hope if the answers are not correct. And for the answers to be correct, I will not be coming in your exams over there to help you, to give you a hint after every question. This is okay. We are right now in a controlled environment where your stress is controlled because you have the pause button. Yes. Your particular anxiety levels can be controlled because you have the cross button where you can close the video and think, I will revise and then I will see the video again. It can be done because you're in a controlled atmosphere, controlled environment. But very soon you are going to step into your exams. And the moment you step into your exams, your pressure will start increasing. Your pressure will start increasing. Your pressure will start rising. And that point of time, what will you do? At that point of time, what will you do? How will you resolve or how will you overcome this issue? Understood? That is the reason I'm saying read, learn every concept very clearly, very perfectly. At least go through the entire summary notes that I have made for all of you. If you have it, great. If you don't have it, get in touch with me. I am there on Facebook. I'm there on Instagram. My name is Kachalia. Everywhere. You can find me anywhere. Get in touch. You want question bank? I will give you. You want comprehensive notes? I will give you. In PDF form, I will give you the comprehensive notes if you want. You want summary notes? I will give you colorful printed copies. You want to check the book? You want to see demo pages? That also I will give you. I'll give you the demo pages also. So if you want to verify the quality of my book. See, I don't fear because I know how much hard I have worked in making that book and how many chartered accountants we have produced because of that book. Students, of course, they have put in a lot of efforts, but when we receive messages saying that, sir, your notes have helped me to crack the exams, that gives us a feeling of satisfaction. And every teacher will do anything to get that feeling of satisfaction. And hence, I am requesting all of you, stay updated with the notes. If you have yours, fantastic. If you don't have yours, grab mine. But make sure you are updated with the notes and you are thorough with the concepts before you answer the questions over here. All right. Well, enough said. Let's go on to the next concept. The next question on the screen. It says F&I Limited. It's a listed company as per the Companies Act 2013, and Mr. Abhishek is the CFO of this company. The CFO, Mr. Abhishek, has been in full-time, so he's a full-time CEO. Okay, a whole-time KMP. Are you trying to say whole-time KMP, sir? Well, I just said it. He's a whole-time KMP over here. Now, Mr. Abhishek has been offered to be a whole-time director in M&N Limited. Well, sir, he is a whole-time KMP or a whole-time CFO in F&I Limited, and he got an offer in M&N Limited to be a whole-time director again. Is it possible for one person to be a whole-time member in two companies at the same time? Well, do I give you a hint? All right, wait, let's read the question. In which more than 51% of the paid-up share, it's a game-changing point. They are saying M&N Limited is a company where more than 51% of the share capital is held by F&I Limited. So they are holding what? A holding and subsidiary relationship. They are having a holding and subsidiary relationship. Now, you tell me, can Mr. Abhishek take this offer? Take this offer of becoming a whole-time director in M&N also, where he is already a whole-time CFO in F&I Limited. Hint for you. Refer section 203 very, very thoroughly. Don't only read the provisions, but also read the exceptions. All right. I hope that is an enough hint. Your time starts now. Are you loving it? Yes? What is the answer? Can he become a whole-time director? Yes or no? Sir, without reading the exceptions under section 203, our answer would have been no, sir. He cannot be appointed as a whole-time director in any other company if he's already a whole-time KMP in one of the companies. But sir, because it is a holding subsidiary relationship, answer is answer C, where they say Mr. Abhishek may proceed with the offer of becoming a whole-time director over there in M&N. Because, why? Because, sir, it's covered in the exceptions. Yes or no? All right. So if this is clear, well, we are left with 3 more questions before the episode ends. Yes, we are left with 3 more questions before this episode ends. And anyway, why waste time in discussion and rather solve the problem? Hasmukh Limited, incorporated under the Companies Act 2013 as a whole-time director, Mr. Ram. Mr. Ram has been reappointed at the AGM held on 28th August 2019. Date to be noted, my friend. Date to be noted, 28th August 2019. They reappointed Mr. Ram. Mr. Ram has served as a whole-time director in the company for nearly 4 years. He has 4 years already over. And his tenure would expire on 24th December 2020. 24th December 2020, his tenure is going to expire. So if they want to reappoint him, 24th December 2020, so 23rd December 2019. 23rd December 2019 is the 1 year gap before the expiry of his term. In that 1 year, you can reappoint him. Here what they are saying, they reappointed him on 28 August 2019. Is it before 23rd December? Yes, sir. Further, the company's upcoming AGM scheduled to take place on 25th October 2019. In the said AGM, Mr. Ram has been reappointed. Mr. Ram has been reappointed as a whole-time director for his last tenure. As a chartered accountant, you determine the validity of this reappointment. Can he be reappointed? Is the reappointment done 1 year before the expiry? Sir, why are you saying the answer? I am not saying the answer. It was a hint which I gave you. We have solved this kind of a question just some time back in today's episode itself. Read section 196 again if you have forgotten and tell me the correct answer. Your time starts. All right, done. No more time. I guess I gave you a couple seconds extra, did I? Well, is the appointment valid or invalid? This question does not require any discussion because we have already discussed such type of a question earlier, and the answer, of course, is very, very clear. Reappointment is invalid, totally invalid in the eyes of law because reappointment can be made only 1 year before the expiry of the term, and here they decided to reappoint him in October and not on or after 23rd December 2019. Hence, it will be considered to be invalid. Go to question number 19. No waste of time. 19. MDH Masala Enterprises Limited. Whoa. It's a public company incorporated under the Companies Act. Into the business of trading of various chaat masalas. All time pass. Mr. Vinayak was appointed as the CFO of the company. Okay. 2nd July 2017 by the BOD. Okay. In the upcoming board meeting scheduled on 30th of April 2020, Mr. Rinkesh, whose age is 55 years, okay, was appointed as MD of the company. So at the age of 55, he was appointed. He can be appointed for a period of 5 years and 5 years and 5 years. No problem up to the age of 70 years, right? All right. Then the BOD also made a reappointment for another term of 3 years of the said membership. Okay. Further, in the AGM of the company, which was held on 30th June 2020, appointment of Mr. Rinkesh was approved by the company. Company means shareholders, and the members also noted the reappointment of Mr. Vinayak as the CFO for another term of 3 years. Okay. You are required to state whether the reappointment of Mr. Vinayak is valid. Who is Mr. Vinayak? Mr. Vinayak is the CFO of the company. He is the KMP of the company, right? So can he be reappointed for a period of 3 years as he was, or can he be reappointed at the AGM? And if yes, then can the reappointment be done for a period of 3 years? Yes? No? Well, the floor is all yours. The screen is all yours. Check the correct answer and we shall discuss it after 30 seconds. Your time starts. Time's up. And here we are to discuss whether the appointment is valid or invalid. Tell me, what's your answer? Do you think it is valid? Do you think it is invalid? Do you think it is invalid? Tell me why it is invalid. Do you think it is valid? Do you have reasons for making it valid? Well, let's discuss it with reasons. We have the answer on the screen, and the answer says, yes, sir, the reappointment is valid because I don't see any reason why it should be invalid. Appointment. Anywhere you see, in the entire provisions of the law, appointments are done for a maximum period of 5 years. And when it says maximum period of 5 years, it can be 1, 2, 3, 4, 5. It can be anything. Here they decided to appoint him for a period of 3 years, which is not wrong at all. Do you think so? Yes. So the appointment which was done for a period of 3 years of Mr. Vinayak as the CFO of the company is totally valid in the eyes of the law. Right? Let's go to question 20, and the answer is on your read. Go Dairy. Go Dairy Company Limited, a public company which is incorporated under the provisions of the Companies Act 2013, is in the business of selling dairy products through online mode. Fantastic. Mr. Dhawal is holding the position of a whole-time director in the company. Okay. During the financial year ended March 2020, the office of Mr. Dhawal got vacated on attracting disqualification under Section 164 of the Companies Act. Mr. Dhawal is a whole-time director and he has been attracted to Section 164, causing disqualification of the director. You are required to advise to the board. What the advice required? You are required to advise to the board of directors to fill the vacancy of Mr. Dhawal, considering the provisions of the Companies Act 2013. Tell me, is this a vacancy which is possible to be filled? Yes, sir. Is this a vacancy which is required to be filled? Yes, sir. Maybe. Tell me. Sir, normally, as per the provisions of the law, where woman director or independent director offices are vacated of a woman or independent director, sir, over there we do the provisions of at least 3 months or before the next board meeting, whichever is later, the vacancy should be filled. That's what we do in case of a woman director. But sir, here he is not a woman director. He is not an independent director, sir. He is a whole-time director. So can you say within 3 months or next board meeting, whichever is later? Absolutely not. You cannot even think about it. If you have thought about it, you are a criminal. You are a criminal. Your concepts are absolutely not clear only, I would say. So don't even dare to think about it. That is out of question. Sir, then what? Then what are you asking me? Then what? Well, then many things can be there. Many things can be there. For instance, he is a whole-time director of the company. Where a whole-time director of the company is resigning, there are probabilities also where the maximum number of directors are falling below the minimum requirement of 3 to 1. Yes? If the maximum number of directors are falling below the minimum requirements of 3 to 1, it is a standard rule of the law. You might have studied this in CA Inter also. That any such vacancy created shall be filled within a period of, should I say it? Or should I give you time to think? Well, why should I say it so easily, man? Take 30 seconds. The time is all yours. We will get back after 30 seconds to discuss the answer. Time is up, and the answer is the casual vacancy. The vacancy which is created, I won't say it is casual, but the vacancy which is created over here must be filled, may be filled, shall be filled by whom? Shareholders or board of directors? Sir, shareholders is not an option because on the screen we can see the 4 options, and all the 4 options are talking about board of directors only. Well, you are smart enough. So it shall be filled by the board of directors? Yes, within 3 months, 6 months, 2 months, or 1 month. Tell me, sir. We read the provisions of the law and we remember the concepts of CA Inter also, right? Any such vacancy undoubtedly has to be filled by the board of directors within a span of 6 months. Yes, the answer is B, within a span of 6 months from the date of such vacancy. If you got this answer, then I'm glad your concepts are clear. Yes. With that, we come to an end of our episode number 2 of Who Wants to Be a Logician. And I hope you enjoyed the session. I hope you got many answers correct. Well, gradually, as our episodes will increase, we are gonna make it really a tough bet for you. Concepts deeper will be involved, maybe some calculations may be involved, and I will need your concepts to be very, very clear. Time will be same, 30 minutes to answer the question, 30 seconds to answer the question. See you in the next episode very, very soon. Until then, this is Professor Harsh Kachalia signing off. God bless you all, guys. Stay home, stay safe, take care of your parents. Love you all. See you in the next episode. Bye-bye. God bless.